Good afternoon. My name's Sarah Rogers. I'm the head of the housing management team within the housing litigation department at Forbes, and I've been recently promoted to senior associate, and I've been assured that that's not just because I'm getting old. I think the beauty of this Q&A actually is going to be that I can just assume you're all laughing at my really bad jokes. So anyway, I'm sure you're all aware that as a result of the coronavirus, the new Coronavirus Act 2020 came into force around the 27th of March. And that basically brought the country to a standstill, but it also extended our notice of seeking possession and our Section 21 notices to 3-month notices, and stayed any possession proceedings that were already ongoing until at least the 25th of June. I had planned to talk to you all about notices to quit at the Bury seminar, because I have to say that in my job, the most queries I get usually relate to notices to quit, when they can be served, how they can be served, who they can be served on. So I thought what I'd do is start by going through some of the common misconceptions and queries that I get, and then I'll move on to deal with the questions that I've already received. And then if anybody can use the Zoom webinar chat to ask me any questions, then when I finish dealing with the questions I've already got, then I will try and deal with the further questions that have come in while I've been talking. So the first misconception that I really want to deal with is the fact that a notice to quit must be in writing. I can't tell you that the number of queries I do get from clients who indicate that they've had a termination notice from the tenant and they want to know what they need to do now to obtain possession. And I will ask for that's not good, is it? I will ask for the notice to quit, and when they send it, and what they do is they then say, oh, it's a verbal notice to quit. So one of the things I want to deal with is the fact that you can't have a verbal notice to quit. It must be in writing. Section 5 of the Protection from Eviction Act specifies that it must be in writing, it must be in the prescribed form, and it must give 4 weeks notice to quit. In addition to that, another thing that I often have to deal with is the fact that the notice to quit needs to end on the last day of a period of the tenancy. And in order to work that out, you need to make sure that you've got the tenancy agreement relating to the case. I recently had a case where the tenancy commenced on a Friday, so arguably the weekly period of the tenancy ran from Friday to Thursday. But the remainder of the tenancy confirmed that the rent was due to be paid on a Monday, and it also confirmed that if the tenant was to give notice to quit, that notice must end on a Monday. So because of those clauses, we could clarify that the notice to quit from the tenant needed to give 4 weeks notice ending on a Monday. But it's also always worth having a savings clause on your notice to quit, which is basically a clause after you've inserted the date and the day that basically says if this day is wrong, then whenever the next day is that a period of the tenancy would end, that's when this notice will expire. And that will then save you if the day happens to be wrong, as long as you've given enough time between the notice to quit expiring and you actually issuing possession proceedings. This also helps because the time starts to run from the date a notice to quit is received by the recipient, which at this time is quite difficult to establish, especially because we can't have face-to-face meetings where we used to take notices to quit off the tenants face-to-face. So obviously the day it was signed was the day it was received, and also because we can't conduct home visits, and we may not even be able to hand deliver many notices to quit at this time either. Hopefully your tenancy agreements allow for service to be determined on the second day after posting if it's been posted, or that it's obviously deemed served on the date that it's hand delivered. And this should, in most occasions, be sufficient when it comes to determining the date that the notice was served. In my experience as well, it's best to use every means at your disposal to get that notice to quit to the attention of the tenant. So it may be that you have their forwarding address. I know it's not often, but sometimes you have their forwarding address. So as well as serving a copy of the notice to quit at the property, you should also send a copy to their current address. In addition, it may be that you have an email address that they provided at the outset of their tenancy, in which case you should email a copy of the notice to quit to them. And if all else fails, you could take a photograph and text it to them. And in addition to that, sometimes if the property is boarded up, or like a situation I had recently where the tenant had decided to put a metal plate across the back of the letterbox, you can put the notice to quit on the front of the door, and then that way if the tenant does return, they will see it. Another query I get a lot of the time is that the tenant wants to give shorter notice, and I can tell you that if they are a sole tenant, then you can accept shorter notice. But where they are a joint tenant, you must always obtain a valid 4-week written notice. However, what I will say is if they have occupiers in the property, there will be a risk that those occupiers will remain in occupation, especially if they're over 18, when the actual tenant leaves. And because of that, and because of the fact that you might want to rely upon the tenant notice to quit, I just think it's safer to get a valid 4-week one, so there can be no argument by the occupier that the tenancy hasn't been validly terminated, and no argument that you're not allowed to recover possession of the property and that they need to vacate. The other thing that many clients confirmed to me is that they've served a notice to quit on an occupier. They've addressed the notice to quit to the occupier and explained that they only have 4 weeks until they must leave the property. So that's another misconception. You can't serve a notice to quit on an occupier. You can only serve a notice to quit on a tenant, and usually in one of two circumstances. So the first is that they're failing to live in the property as their only or principal home and they have no intention to return. And the second is that they've died. So I'll come on to abandonment because I do have a question about it, but in relation to when they die, the only way to terminate the tenancy, validly terminate the tenancy when the person dies, is to serve a notice to quit on the personal representatives of the deceased, and you serve that by posting it, sending it, hand delivering it to the property, addressed to the personal representatives of the name of the deceased, and then I write the deceased in brackets as well. And in addition to doing that, you also at the same time, and it has to be at the same time, need to lodge a copy of that notice to quit with the Office of Public Trustee. And you also have to complete an application form and pay the Office of Public Trustee's fee, which is £40. I appreciate that in practical terms, often you might only get a phone call from a deceased child or partner when they've already cleared the property and they're just ringing up to let you know that the tenant's died, they've cleared the property, and they literally just want to give you the keys. So I appreciate in those circumstances you may choose to just treat that as the tenancy ended and re-let it, but I can only advise you that that's not the strict legal position. And ultimately the tenancy will remain live if it's not validly terminated by the service of a notice to quit on the personal representatives and lodging it with the Office of Public Trustee. Appreciate the risk can be small and that 9 times out of 10 there'll be no repercussions. Deceased tenants can't bring an unlawful eviction claim against you, but there's always that chance, that risk that somebody might come out of the woodwork at a later date and claim that you evicted them or that you got rid of belongings, things that belong to the tenant that were rightfully theirs. So like I say, that is the strict legal position. In relation to tenants that appear to have abandoned the property, that brings me nicely onto a question that I've had from Michael Healy at Your Homes Newcastle. Thanks, Michael. Hi. And he's asked about proving intention to return and establishing whether a tenant is using the property as his or her only principal home during lockdown. So this can be quite tricky because obviously you're not able to make the usual checks that you might normally make. You probably have an abandonment procedure and you'd like to go out to the property and see whether or not they're living there. do things like put sellotape across the door and then go back in a few weeks to see if it's been moved, things like that. So I think in each case, you're going to have to consider it on a case-by-case basis. A recent case I had, the tenant had not been seen since February, and my client had made attempts to contact the tenant, but also to speak to an apparent alleged unlawful occupier who'd been left in occupation, or rather possibly a subtenant. The information they received was that he was probably renting the property from our tenant. Couldn't make any contact with the occupier or the tenant themselves, so I sent a letter in March to the tenant to ask him to get in touch and confirm what his situation was and whether he was living at the property. Didn't hear anything. So in March, after the changes to the notices, I served a notice to quit, but also a notice of seeking possession. Because remember, failure to live in the property is your only principal home, it's also likely to be a breach of the term of their tenancy, as is illegal subletting. So it may be that you can serve a ground 12 notice of seeking possession on the tenant in addition to a notice to quit. And furthermore, in this particular case, the tenant was in rent arrears, so I relied on grounds 10 and 11 as well. The notice to quit was due to expire on the 24th of May, and the NOS still hasn't expired. It's due to expire on the 21st of July, with it having to be a 3-month notice. The tenant got in touch on the 15th of May, so before the notice to quit had expired, and he explained that he'd been away abroad and then he'd got stuck and he'd not been able to return to the country due to the lockdown. He explained that he was now back in the country, he's back in the property, he had no subtenant, and his intention was obviously to remain living in the property. So in my view, it'd be quite foolish for the client in that case to seek to rely on the notice to quit and also the notice of seeking possession, given that the tenant returned to the property before the notice to quit expired and would certainly be living in the property as at the date when we had our first possession hearing. I phoned the tenant and made him aware that if he was to be away from the property for more than 28 days, he should have notified my client. And I explained that we wouldn't be pursuing the notice to quit at this time, but that the notice of seeking possession obviously lasts 12 months, and should we receive any further information that he's not living there as his only or principal home, we could look to enforce that notice of seeking possession. So we've left that case like that. But as I say, I think you're going to have to look at each case on its own merits. The cases where I've already issued possession, I'm just waiting to see what the position will be when I finally get a first possession hearing. But I think, in my view, you need to make sure that as well as serving a notice to quit, that you also serve a notice of seeking possession if you're able to. And I say that because if you can't rely on the notice to quit, which is obviously mandatory possession, then you can fall back on the notice of seeking possession. And that allows you the opportunity to agree to a suspended possession order with the tenant. And that suspended possession order could include a term that they obviously live in the property going forward. And it might also include the right for you to make ad hoc visits to check that he's actually living in the property. So it just gives you more scope, really, to deal with the possession proceedings, especially if they don't return until after the notice to quit has expired, but before you get to your first possession hearing. I suppose I should point out at this point that occupiers left in occupation, while you can't serve them with a notice to quit in their own name addressed to them, you do still need to provide them with a copy of the notice to quit you're intending to rely on. And you must make sure that you comply with the pre-action protocol, part 3 of the pre-action protocol, which basically says that you need to write to the occupier, usually with a copy of the notice to quit, to advise them that the notice to quit has been served and that the tenancy is going to terminate and the date upon which it's going to terminate, and to also invite them to make written representations as to any personal circumstances or other matters that they want you to consider before you issue your possession claim. Furthermore, the protocol makes it clear that if they do make representations, you also need to go back to them to confirm why you are still progressing possession, or if you decide not to progress possession, what your decision is and why, basically. And if you don't do that, that would be a breach of the pre-action protocol and would be sufficient for the court to strike out your claim if you didn't comply with it. So it's very important that you make sure you comply with that section of the pre-action protocol. In addition, if you're relying on a tenant notice to quit, do make sure that you redact, if there's a forwarding address, make sure that you redact that forwarding address out of the notice to quit, because they could be fleeing domestic violence. The other tenant may be the perpetrator of domestic violence or occupier, either way. And to be honest, it's probably just good practice under GDPR to redact any forwarding address, just because it's personal information that you're not at liberty to disclose to the occupier that's remained in occupation. So that pretty much sums up some of the questions I get quite a lot of and some of the misconceptions, but I'm going to deal with the remaining questions now. So I can see that Claudia Walsh from Leeds Federated Housing Association has been in touch. Hi, Claudia. And she sought some clarification in relation to notices to quit for assured shorthold tenancies. I think, Claudia, I might need a little bit more information from you about this question, because ultimately under an AST, the tenant usually has to give at least 4 weeks written notice of his intention to terminate. And as with an assured tenancy, the landlord can terminate an AST where the tenant's clearly not living in the property as his only or principal home. I do wonder if you had a specific query around ASTs, whether you might want to get in touch with me after the event, and I can maybe see whether I'm misunderstanding the question. There's anything more I can do to help you with that. The third question is from Jo Sylvester at Ongo Homes. Hi, Jo. And she's asked a good question. She's asked whether or not the notices to quit need to be extended to 3-month notices. Now, I haven't seen anything from the government indicating that notices to quit need to be extended to 3-month notices. Can't tell whether that's an oversight or not, but ultimately the moratorium period is due to end at the end of June, so it may be that if they do want to amend the notices to quit, they kind of missed the boat. What I will say is that even if you issue a claim in reliance upon a notice to quit, the court won't list it for an actual hearing. They'll issue it, they'll issue your claim, but they won't list it for a hearing until after the moratorium period's been brought to an end. Presently, that's meant to be the 25th of June, but of course, we don't know. The government may extend that deadline. I can, however, confirm that the court will list possession hearings against trespassers, and by that I mean true trespassers in the sense that they've entered the property and remained on the property without permission or consent. So that's persons unknown, basically, true, what would have been called squatters. Sadly, we don't really tend to find that situation much, because usually it's an occupier that's been left in occupation who once had the right to remain there because the tenant gave them permission to do so. So I don't really think that lifting of that slight reduction in the restriction has been particularly helpful to social landlords. I have a third question from Elizabeth Chan at Weaver Vale Housing Trust. Hi, Elizabeth. And she's asked what approach I'm taking to failed succession cases where the deceased tenant's occupier may have a right to inherit the tenancy under the rules of intestacy. So even though they don't meet the criteria to succeed, they may have a right under the rules of intestacy. So where a person doesn't leave a will, there's a sort of hierarchy of people that can inherit that person's estate and also potentially the tenancy. Elizabeth rightly pointed out in those circumstances you need to serve a notice to quit, but also a ground 7 notice of seeking possession, which is essentially a notice that you can serve on a person who's entitled to inherit the tenancy. It's usually a 2-month notice, it's now a 3-month notice, and it must be served within 12 months of the date of the tenant's death, or later if or the date that the landlord became aware of the death, because often that could be a much later date. But in any event, you've got 12 months from the date to get that notice of seeking possession served. If you don't do it within that time, you lose the right to do so. And if your notice to quit fails because they're entitled to inherit, then you may well be left having to give them a tenancy. But ultimately, Elizabeth's asking me whether or not we definitely serve both the notice of seeking possession and the notice to quit, but would I then issue possession proceedings in reliance upon just the notice to quit, and then only raise the ground 7 notice of seeking possession if the defendant sought to defend the proceedings, or whether I just bung it all in together. I have to say my view is to put them both in together, to make a claim based on the notice to quit, or in the alternative, the notice of seeking possession. I think it's better to put everything in together from the beginning. I think the court might question why you didn't rely on your ground 7 notice from the outset, and why you're now seeking to amend your claim at a later date. I suppose the only reason for doing it separately, or for relying on the notice to quit first and then amending your claim later, would be that you could issue the claim under normal circumstances much more quickly, because you'd only have to wait for 4 weeks for the notice to quit to expire. Although, like I've already said, a ground 7 notice of seeking possession is a 2-month notice anyway. So it's only an additional month you'd now have to wait before you could issue possession in reliance upon that. And then my final question that I had before the session started, I can see I have got one further question already, which I'll come on to in a minute, is from Lei Chan at Southway Housing Trust. Hi, Lei. And Lei has asked me whether or not, where we've got a failed succession, whether you can still act on it where there's no proof of residency. The simple answer to that question is yes. If the occupier is not entitled to succeed under statute, or entitled to succeed under the terms of the tenancy agreement, or via your policies and procedures, then you can serve the notice to quit on the personal representatives of the deceased and lodge it with the Office of Public Trustee, and then you can issue possession proceedings against the person that's remained in occupation and who isn't entitled to succeed to the tenancy. Just going back to the question from Elizabeth, I would also make sure, just in case they have a right to inherit the tenancy, or if they clearly have a right to inherit the tenancy, that you also serve a ground 7 NOS. It goes without saying that all the advice I'm giving about issuing your possession claim, especially where you're issuing a claim in relation to mandatory possession in reliance upon a notice to quit, that you do need to consider the proportionality of your decision to press ahead, and you do need to think about any Equality Act considerations. If a person's looking to succeed the tenancy but they don't meet the criteria, but they have a disability and require that house, or if they went through the normal channels of seeking housing through a housing list and through the council, whether they might be offered a property similar to the one that you're seeking to evict them from, then it may be that you can bend your policies and procedures to fit those particular circumstances. It may be that even if they're not allowed to succeed, you may want to grant them a tenancy of the property for that reason. But of course, you must comply with your allocations and lettings policy. You can't let people get a tenancy through the back door, but it's just something that you do have to bear in mind, because arguably the tenant could seek to, rather the occupier, could seek to defend possession proceedings if you didn't take into account their disabilities and things like that. So I would always recommend, if you're aware of any disabilities, that you complete an Equality Act review in relation to those before you press ahead with any possession. So I just said we do have one further question, which is from Alexis. Thank you, Alexis. And she says, hello, what is your view on the government's guidance in relation to not issuing possession claims unless you have very good reason to do so? Is this still the case after the 26th of June? Well, firstly, my understanding is that after the 26th of June, the moratorium period will be lifted and we'll be able to issue in the normal way. But of course, we will now be waiting for 3-month notices of seeking possession to expire. I was having this conversation yesterday with another attendee actually about whether or not it might, in those circumstances, be worth serving a new notice, especially if you're going on ground 14 on antisocial behaviour, because you'll be back in a position when it ends to serve a notice and issue possession proceedings straight away. I think where possible you should wait for your 3-month notices to end, if for any other reason other than the fact that the courts are going to be absolutely inundated. But I have a couple of situations. So I have a case at the minute with a Section 21 notice, and when they were served, they were 2-month Section 21 notices. but they're actually going to expire in July because, of course, I only have 6 months to issue possession until they expire. So I'm going to issue those claims. Now, I appreciate that the judge or the courts may then take a view and not actually list it for a hearing until the moratorium period has been lifted. But ultimately, I'm going to have to issue those claims, because if I don't, I'm going to lose the right to do so. I'm going to have to start the whole procedure again. And if my client has to serve new Section 21s right now, then those Section 21s will have to be 3-month notices. So I'm sorry to say the usual solicitor line, if you'll have to look at it as a case-by-case basis, but you need to be reasonable. You need to think about why you're issuing the claim, whether you really need to issue it now or whether it can wait. I've got a lot of cases with unlawful occupiers sat in occupation who until recently weren't able to move even if they'd located somewhere. So I've sent out a lot of letters indicating that this is our position. We will be bringing possession once the lockdown comes to an end. The notice to quit has been served, the tenancy has been terminated. We will let you live there as long as you pay the use and occupation charges until such time as the lockdown has been brought to an end. But do not think that you've been given a tenancy or that you're going to get to remain in there long term. As soon as lockdown ends, we are going to have to take action against them. So I think that answers your question, Alexis. Again, I mean, if you've got a specific set of circumstances and you want to ring me about it afterwards, please do so. And then I've had another question from Leigh asking, do you think the courts will continue the extension? It's really hard to say. They've opened the schools just recently, haven't they, since yesterday. Obviously, the government wants the free movement of people to recommence at some point. So, but it's, you know, I couldn't tell you. I really couldn't tell you. I don't know. A lot of my court orders don't refer to a date. Some of them refer to a date and say that a possession hearing will be listed after the 25th of June. Others just say a possession hearing will be listed once the restrictions have been brought to an end. I'm just getting a few more questions, but I'll just have to do some scrolling. Oh, Alexis has confirmed that's helpful. Thank you very much. Right, I just have a further question from Tracy Ferguson-Black at MSV. Hi, Tracy. And she said, if we issue a notice of seeking possession pre-lockdown, can we issue after the 26th of June? Will it be suspended for 90 days and then listed? So any NOSP that you've served will have a deadline in it, and obviously that will be a 3-month deadline. So the closer we get to the end of June, that the less, I suppose, the less likely you're going to want to serve a notice of seeking possession, because you're going to have to wait 3 months. Whereas if you wait till the moratorium period to end, you could then serve your NOSP, and it wouldn't have to be a 3-month NOSP. We might be back then to the way it used to be. So no, it should be that once the moratorium period is ended, the court will issue the claim and list it for a hearing straight away in the usual way. But what I can't guarantee is that the moratorium period will end at the end of June. I hope that deals with your question. Another panellist, Jo has confirmed, Jo Sylvester at Ongo said that she'd heard the courts may extend it till October, and that could well be the case. We'll just have to wait and see, I'm afraid. Does anybody else have any other questions? No? Right, well, that's everything from me. Thank you very much for coming. And hopefully I'll get to see you all in the flesh at some point in the near future, and I can get out of this kitchen, which I'm totally sick of. So see you all. Bye.